Karen Reed adds another powerhouse attorney to her defense team. Meanwhile, Team Turtleboy makes good on their promise as they have recently filed a Rule 17 motion for none other than Meatball Morrissey's private email account. Because remember those discreet / not so discreet emails he was sending to all those judges via his personal iCloud account? Well, now it seems like that is all becoming well and fair game, and boy oh boy, am I excited. Hello, and welcome to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people. People who hit 2K on this channel, thanks to all you beautiful and wonderful people out there who have been supporting me from day one. I know it has been a little bit of a slow moving as of late, but I promise to make good on the goods that I have promised you. So thank you so much for hanging with me. As I promised via my community tab earlier, I will be making a donation of my first payout from YouTube. It took a couple of months because I had to get my tax information all settled, being married and having to change my name and do all that bull crap. So I will be making a post later today. 10% goes to Turtleboy's defense fund, and then the other 10% of those earnings will go to Karen Reed's defense fund. But first, it's a beautiful day in the neighborhood, as Mr. Rogers said, because Karen Reed has added a brand new powerhouse attorney from the state of York, New York, that is, Nueva York, for you Spanish-speaking or bilingual folks, from where I am originally. So David Gannetti filed a new motion in Norfolk Superior Court, indicating that he has now added Robert Alessi. I guess he's of the Italian persuasion, a partner at the New York-based firm DLA Piper, to Reed's group of legal representation. Reed has requested that, and let me just, make this a little bit so you guys aren't squinting like I am at my screen right now, right? Don't you love getting older? It's fun, right? It's so much fun. Reed has requested that Mr. Alessi be associated in as counsel of record. The motion reads, Alessi has specialized skill and knowledge in representing defendants in matters of this nature. Alessi serves as the global vice chair of DLA's Piper's energy sector and is regularly called upon by Fortune 100 domestic, not to be confused with Fortune 500, domestic and international clients to handle their most significant energy, environmental, and financial service matters, according to the firm's website. So, I mean, he seems to have like a pretty cool bad arse background, and we'll read very briefly through the motion. It's about a page, but this is our guy right here. I mean, he looks like he is kicking butt and taking names, right? He honestly, he kind of gives me Alan Jackson vibes a little bit with like the haircut and everything. So, I don't know, but he seems to have a pretty interesting background. So this was from the little section that they quoted in the article, but be they the defense of government criminal enforcement actions, judicial and administrative trials, and appellate litigation. So I'm assuming this is in direct results of the SJC appeal, which they were in court a couple weeks ago. We're still waiting to hear from the SJC as to whether or not they are going to overturn Bev's ruling of the motion to dismiss counts 1 and 3. So we will see on that, but the big question I have, I mean, I think she's more in a position of adding more manpower to her team and not so much replacing. I know a lot of people had questions, is AJJ going? I don't know why everybody always thinks that. I can't imagine why Alan Jackson would give up the opportunity to see this case through to the end. I mean, this is one of the biggest cases of the century, period, end of story. I mean, this is as notable, I would say, as the Lacey Peterson, Scott Peterson case, the Menendez brothers. Like, as much, and the hype of all of it, the OJ, that's been compared to as well. Not that they have any similarities in terms of the investigation or the case itself, but in terms of the notoriety and how much mass coverage it's gotten, especially over the last several months since the trial really began. It's a lot. It's definitely high profile. So I can't really see Alan Jackson, just for the, you know, pure idea that this is probably going to be one of the biggest cases he's ever going to be participating in, aside from, prosecuting Phil Spector. But still, nonetheless, I mean, if he can get an acquittal, which he will, Karen Read will be acquitted. She's not going to jail. She never will be. Period. End of story. And if you're watching this video, I know you feel the same way too. So I don't see him making his Houdini disappearing act anytime soon. I just think this is just, adding the cherry on top of the sundae, right? He's been repeatedly acclaimed for his multifaceted practice in leading legal rating publications, the best lawyers in America, 20 consecutive years, including Lawyer of the Year recognition. Okay. This was especially interesting, right? He represented the governmental entity charged with planning the rebuilding and revitalization of the World Trade Center and Lower Manhattan in the aftermath of 9/11, having been selected to do so as a result of a national competition. Wowza. Robert's general civil litigation practice encompasses a wide variety of commercial matters in state and federal trial and appellate courts, including multiple federal and state court actions arising out of one of the largest bank frauds nationwide. Many of his trials, I'm curious to know what exactly that is. I'm sure a quick little Google search will bring that up, but for time's sake, I'll let you do that homework on your own, yo. But many of his trials have turned on the direct examination and cross-examination of experts, where he applies his scientific and technical background. So you can read up more on him. There's a couple more paragraphs. Robert J. Alessi from DLA Piper from the great state of York, where I am from, or Nueva York, if you are a Spanish-speaking viewer. So this is the motion that was filed. I'm going to give it a quick download so we can read it a little bit more easily. So yeah, I mean, like, it's a beautiful day in the neighborhood. And I'm very excited to see, again, coming into this saying, not being an attorney. Obviously, that's why I start out every video saying I'm just a person who asks questions, because this is cray-cray. The same kind of questions that I know you guys have as well, too. So I think he's just, another new flavor of the week who's going to help us get closer and closer to Karen Read's acquittal. But, in that first step, right, of getting those counts 1 and 3 dismissed. So, David R. Iannetti. I want to know so desperately what the R stands for, if it's Robert or if it's something like aristocratic middle name like Reginald, right? So I'm going to go with that, even though it's probably Robert or just something, more simple. But in my fantasy land, it's Reginald. So David Reginald Iannetti of the law firm Iannetti Criminal Defense Law Firm. And I also, sorry, my ADHD is kicking in. I also want to know what happened to his sister. Like, is she, because I know she was a big part of the first few pretrial, like, way back when this all started, right? After Karen Read was, like, arraigned and they had all those motions hearing. I think before Alan Jackson even came into the picture. If she's still helping out with this case, but like more so in the background, or if she's like, nah, David, it's all you. I got other clients to assist. I don't know. I'm curious, or if any of you guys know, but I thought that was really cute how it was like a brother-sister duo thing going on. And a member of good standing of the Massachusetts Bar hereby moves to admit pro hoc vice. Add frickin' hoc. Free frickin' gratis. Robert Alessi, so that he may associate Yeah, associate. In as counsel of record for the defendant in the above captioned matter, which is motion for admission pro hac vice of Robert Alessi, on the following grounds. So he's a partner of here. Defendant Karen Reed has requested that Mr. Alessi be associated in as counsel of record in the above captioned matter. So again, I don't know if this is David's idea, Karen's idea, because we know that Karen had the idea to reach out to AJJ back in the dia. So I'm curious. And we all know how smart of a cookie she is. She's very heavily involved in her defense, probably more so than I've seen from any kind of defendant in any case I've followed. Not necessarily covered. I haven't covered a lot of cases, obviously, on this channel yet, but that I followed. So I don't know if that was, done on her part, if it came out of recommendation, if it was a team decision. But nonetheless, I mean, smart decision. Nonetheless, you can never have too many friends in your corner, right? Mr. Alessi has specialized skill and knowledge in representing defendants in matters of this nature. So he's coming in specifically for this purpose. Should the court grant this motion, I'm also curious, it goes from 3 to 6. So like, what is missing from 4 to 5? Like, did those delete and then they just made like a little oopsie and they meant to renumber it? I don't know. But this was the document that I found, and that was shared within Boston 25. I will act as co-counsel during the pendency of this matter. So it'll be him and David Reginald Yannetti. In conjunction with this motion, Mr. Alessi has paid the Board of Bar Overseas a registration fee of $355 as required by the SJC Rule 3 /15 attached here too as Exhibit A, which we do not have access to, but it's just, probably a receipt of, hey, he did this thing, he's good to go, can he be allowed into play in the sandbox, right? Respectfully requests that this motion for admission pro hoc vice of Robert Alessi be granted. Respectfully submitted on today, literally today, David Reginald Yannetti. So here we go. All right. So there's that. Pretty cool news. Now, I know there was some too. I was going to go over this, but I was actually watching Melanie Little's live stream earlier, just a couple hours ago, and she was going over some of the new / not so new filings that were filed earlier today or yesterday by the Commonwealth. That is essentially them just seeking like every email, message, recording, video, etc. from like news publications like NBC 10 Boston. I don't know. I've been kind of out of the loop for the last couple of weeks, and I know a lot of you guys have been totally in this, so I'm still playing catch up, but from what I gather, it's pretty much the same. It's like a copy and paste job, but with like substituting this word for that word, like this news publication for this new news publication. That was my general gist. So I figured instead of boring you and going through that, we would go over this news instead, because this hasn't been talked about nearly as much. I know the Young Jerks has started to talk about it. Obviously, the Glare too. I think Melanie Little also touched upon it. But I thought this is huge, not only for Turtleboy, obviously, but for Team Karen Reed. I mean, this is it's all tied together. So when it comes to Turtleboy, I'm still very much putting the pieces together. So when it comes to stuff like this, I like to refer directly to the source, because he's the one who's going through this, right? And if I can throw any support his way, I definitely want to. So if you are not a Turtleboy newsletter subscriber, you're not part of his Turtle Club, it's only $15, I think, a month. You get access to everything, no ads. Turtle Club, he's hilarious, he's great. I know I don't need to sell him any more than that. I have no affiliation with him whatsoever. I've never spoken to him in my life. This is just me wanting to throw some extra support his way because he's doing God's work in this case. He really is. And now it's coming full circle with what's going on with his case in Karen Reed's case, because it is the takedown of the mighty meatball Morrissey, as his defense team has filed the Rule 17 motion that everybody was like, oh, are they going to do it? Like, if this is such a big deal, why don't they just file a motion? And by God, they did it, right? The Betero letters have prevailed, and Team Turtleboy, Tim Bradle, has taken the reins and filed this dang thing. So let's get to it. So this is the first page of the Rule 17 motion. It's about each page is long, so we'll go through the whole thing. But I like his little breakdown because it kind of sums everything up in a little bit more of an easy to digest way. So now comes Mr. Aiden Carney. That sounds pretty badass, I'm not gonna lie. Because usually it's like you read these things, it's like, now comes the Commonwealth, and I just imagine like this giant meatball with like legs looking like Jabba the Hutt and just like slowly approaching you, waddling. But this sounds like more like the entrance of a Jason Statham kind of entrance, you know? Anyways, herein and respectfully requests that the court order the production of statements referenced herein below and further authorize the clerk magistrate to issue a mass R. Crim. P. Rule 17 summons to Apple, because they haven't responded to the Betero letters. I mean, what will go down in history, and it will be talked about for centuries to come. You bet your bottom dollar. And there was no response to it. So now they're like, all right, well, if you don't want to give it to us, we're going to go to Apple, because if you guys can go to stickers.com and you can do all the ducky goosey stuff that you like to do and spend hard-earned taxpayer dollars on bogus investigations to just create more smoke for the smoke in the mirrors, then we're gonna go to Apple. We're gonna hit up Steve Wozniak, because Steve Jobs is no longer with us. Any and all emails or text messages sent or received beginning on August 10th, 2023 to the present associated with the Apple iPhone and or iCloud account assigned to private subscriber Michael Morrissey, Norfolk County District Attorney, the subscriber, the Mega Meatball, be provided. Subscriber's personal email address to be provided under separate cover to be filed under preliminary impoundment subject to court's order. Further, that the Norfolk Superior Court Clerk's Office receive and retain the information under impoundment. So that's page 1. All right, so and if you haven't read the Betero letters, again, I'm going to link this article in my description box below. You click here, check them out, give them a read, and that'll give you a full, a better idea as to what the heck is going on, what they're referencing here. But here's a quick synopsis. We discovered in the third Betero letter through a whistleblower that Morrissey used a personal iCloud email account to communicate with several judges on 9/29/23, including Stoughton District Court Judge Daniel O'Malley, who denied a harassment prevention order for Chris Albert against Turtleboy the day before 9/28/2023. He wrote the email after Jennifer McCabe contacted somebody in law enforcement, unknown who, probably Tully, and demanded that the Stoughton District Court employee who sent me a copy, meaning Turtleboy, of Albert's public affidavit, be identified. Morrissey did as he was told by McCabe. And yeah, because apparently, like, this is the funniest part. Apparently, barking orders come from Jennifer McCabe, the Queen of Canton, because I guess if you're voted best looking in high school, that means that that title carries on with you throughout your adulthood, even though it's like, girlfriend, you're not in high school anymore. You're not. Like, there's only so much, like, that can really do for you. And I honestly, I'm so curious because it's like we talk about all these, like, cast of characters, right? Because this is a movie. At this point, this has become a freaking movie. This isn't reality, right? Is this real? Or is this fantasy? It's freaking fantasy, right? And I have to wonder, does Jennifer McCabe work? And, like, there's no, like, that's no shade to people who are stay-at-home parents. Like, more power to you, more respect. Because that is a freaking job in itself. I'm seeing how my sister's trying to balance working a job and also being a mom to a 2-year-old, and it is difficult AF. That being said, I'm just curious. It's like, what do you, at this point, because your kids are grown, like, what are you doing with your life? Like, are you, like, head of the book club? Do you, like, are you still on, like, the, I guess, like, the, what is it? Not the Can Select Board, gosh. The parents, school board. Like, what does Jen McCabe do? And, like, more so, what does Nicole Albert do? I'm just so curious because I feel like they're just both, like, massive depressants. And, like, I get it. I struggle with my own mental health too, but I just feel like, who is she to bark orders at the DA of the county she lives in? And he's just like, yeah, of course, I got your back. Like, what does she know? What does she have on him? And why is, like, she Queen Poop? Why is she the Queen Poop? I just want to know. That's why I ask all these questions. It's like, what does she do? What kind of power? What kind of monetary, like, I don't know. Is it money? Is it something else? Did she see something? Does she know something about him? I don't know. But anyways, 2 weeks later, Turtleboy was arrested, and Judge O'Malley issued 8 stay-away orders preventing me from coming within 500 feet of witnesses, including Chris Albert and Jennifer McCabe. And here, I think there's a screenshot. I know it's late, but I'm horrified. The shock and horror that Chris didn't get it. I'm assuming she doesn't mean his time of the monthly gift, right? So thank God Chris Albert isn't pregnant. And I am even more disgusted that for the second time, someone from the court leaked it right away to TB. And again, it's like, if he's just a blogger, why are you guys so threatened by him? It's so, it makes no sense. Make it make sense. Morrissey is not allowed to use a private email account to conduct government business. Yeah. He knows the public record laws allow public to read communications between public officials and matters of public concern, but he didn't want the public to know that he was directing several judges to punish me for meaning Turtleboy, for his journalism in regard to the Karen Reed case, which is why he used this private email account. So you can read this. This is the email. We went over it in past videos. Okay, cool. So then this is the next section of the motion. Further, that the court appoint a special master, independent from, but at the expense of the Norfolk County District Attorney, to review the content provided to the court and provide to the parties all Rule 14 discoverable statements, A, between and among the subscriber and any civilian witnesses or law enforcement witnesses or alleged victims, and B, any ex parte statements to the judiciary concerning the defendant herein or an other witness or person connected to the defense of the above captioned cases or the pending case in Dedham District Court involving the same complainant. That DA Meatball be personally ordered to provide any other Rule 14 discovery, because you know that they love to just say, oopsies, we forgot, we didn't share this thing, like, or we did, but, like, it's the defense, they didn't have the right copy. When we sent it to them, everything looked fine. It's so, like, oh my God. And I know I say gaslighting all the time, and I know that's like a buzzword for a lot of people, but it really is gaslighting at its finest, folks. in his possession, custody, or control, whether on paper storage devices, personal or office devices, where and whatever situated, including but not limited to the readable, accessible, full extraction from Mr. Carney's phone referenced in the communications. Because remember, I don't think he still has gotten his phone back. It's been at the last hearing, or last hearing, one of the last hearings, Bradel was like, yo, it's been like 300 days. And then we find out you actually did extract the contents that you needed like months ago. And we still haven't gotten his devices back. Like, what are you doing? Well, we know what you're doing, but as grounds, the defendant states that the subscriber, Meatball, is the chief law enforcement officer of Norfolk County and the ultimate authority of over all Norfolk County assistant prosecutors, whether designated assistant or special assistant district attorneys. Hint, hint, wink, wink. Hey there, Hank. Hey there, Hank the Tank. As such, he is part of and, in fact, the leader of the prosecution teams in the above captioned matters, ethically prohibited, like any other attorney, from engaging in ex parte communications with justices on pending matters. Likewise, and equally, I have never seen that word in my life. Here we go. Axiomatic. I'm going to go with that one. Any written or substantially verbatim recorded statements he receives or participates in from civilian or police witnesses or alleged victims are statements that must be disclosed to the defense under Rule 14 of the Massachusetts Rules of Criminal Procedures. Because if you want Bill Reed's shiz, and I get it, I know here we're talking about like a totally different case, but it's still the Commonwealth and it's still Meatball. It's still Meatball's palace, guys. But if Meatball and his little buddy, his little special prosecutor, little special Hank Brennan, can say, hey, we're going to get not only Bill Reed's phone extractions, but we're also going to take Janet Reed's phone as well, too. Well, hey, we want yours, Meatball. Cough it up. Cough up those raisins. You know, it's funny because my Uncle Ralph, my godfather, he used to make, I'm Italian, 50%. I'm 50% Polish, and I'm apparently like only an eighth Italian. I'm not very Italian, but my maiden name, which is weird to say, it makes me sound old, is Italian. And my uncle, Ralph, very Italian. I think he's like 100%, right? My cousin is 50-50, 50 Irish, 50 Italian. What a combo. And he used to make I think it was Easter. Every Easter, he would make meatballs with raisins in it. And I always thought that was the weirdest thing. I don't know. Have you guys, like, done that? And, like, Julia, my wife, she also, because she's way more Italian than me. She's 50% Italian, then I think, like, less Irish. I think something like that. She's definitely more than me. And her family, like, does, like, rice balls and everything. And all of, like, that was just so, like, foreign territory to me. I know, like, really Italian people also do, like, the fish and stuff. But I don't know, for my Italians out there, do you prefer your meatballs with raisins or without raisins? I want to know. Not that that has anything to do with anything. But anyways, here, the defense team has received and publicly shared whistleblower information that DA Morrissey has personally communicated in ex parte fashion with the then Chief of Justice of the court, the then presiding Justice of the Stoughton District Court, and other high-level court personnel, disparaging the defendant therein through the use of a private burner email account with the obvious intent to avoid scrutiny from the public through public records requests. Because, you know, if we all saw a meatball was like, yeah, let me just hit on my boys. It was like 2 o'clock, I think, like in some like random afternoon. And he was like, yo, and that like hit the Twitter waves. That would have been crazy. But this is even worse. Because it's like, now you're doing it, like, all sneaky. See Exhibit B to October 17th, my birthday. A letter to Special Prosecutor Cosgrove from co-counsel Betterow. Attached here to in its entirety as Exhibit A. Question. what the heck happened to Cosgrove? Because he was not at, if I'm my eyeballs are correct, I didn't see him at the last hearing. It was just Mello. So I don't know. I don't know if that's because it had to do directly with Lindsay, Gaetani, or LG, or if Mello is back from the dead. Like, he was gone for like forever, it seemed. Like, he went to Vietnam with Donna Adelson. I don't know. He like totally freaking disappeared, and Cosgrove was in as the other human punching bag. So I don't know. It's like it says Cosgrove is co-counsel, so I'm assuming he's still on. Maybe he just was busy that day. I don't know. But if you know, let me know. DA Morrissey's, or excuse me, DA Meatball's communication to the court personnel also contained a screenshot of a partial communication, i.e. Rule 14 discoverable statement from an alleged victim listed in one of the indictments against Mr. Carney. I think we can all piece that one together as to who that is. Morrissey complaining about leaks of public information to defendant Carney, according to a number of witnesses in this matter, and appending one such statement in his personal possession in the ex parte communication. Morrissey's illicit communication literally solicits responses from the justices and refers to additional statements justifying the defense inquiry for further documents and communications. And you know what's even like more like effed too? Like, wasn't he also on that email thread, right? Or email chain with Jennifer Coffindaffer too? So it's like, you have a problem with Turtleboy talking to Karen Reed? Meanwhile, you're talking to people like Twitter influencers. Like, what? What? Like, you're literally paying influencers to promote your brand, to promote your statement, right? Your false theory about what happened to John O'Keefe. Morrissey's illicit communication literally solicits response from the judges, from the justices, and refers to additional statements justifying the defense inquiry for further documents and communications. As attorney Tim Bradel pointed out, the whole purpose of using the private email account was to evade public records requests. Exactly. Because if you're not doing anything shady, why not put it on public record? Because you're doing something shady, Meatball. Get back in the oven. This was a scheme to avoid handing over discoverable evidence, including communications with the same judge who arraigned Turtleboy 13 days after receiving the email from Bradel. To the extent the district attorney or his agents have gathered such undisclosed statements from a number of witnesses and or communicate with such persons on their personal devices, the entirety of such statements are discoverable under Rule 14, and the use of a personal device does not sanitize these communications from discovery. See Friedman. Appeals court noting leaving undisturbed successful request for agency employees' personal cell phone usage where public matters discussed. Further, the plain language of Rule 14 makes no distinctions as to the locations of discoverable statements and is focused instead on their possession, custody, or control. See MSR Crim P14 generally. If a prosecutor brings a written witness statement or a medical examiner's paper copy of a report home from the office, it does not change the equation. The limit does not exist. And as we evolve into the digital age, which, I mean, it seems like Cosgrove and Mello, like, they look like the freaking crypt, especially Mello. He looks like the freaking crypt keeper. And as we evolve into the digital age, there are toys to receive, create, and store statements with witnesses or other discovery on their personal electronics equally carries no weight as far as Rule 14 is concerned. Instead, the court should be focused on the obvious attempt to elude discovery obligations, sanction such actors when discovered, and make broad findings and pronouncements that such communications must be routinely disclosed, because you guys have a problem with disclosing stuff, right? When they are not, sanctions will be applied. Meatball's ex parte communication was a complaint to the presiding judge sitting on Mr. Carney's case, attributing negative conduct to Mr. Carney on a private email. So just to scroll back up, I noticed that I was like, oh, you guys can read it. But I mean, just to like read a little bit and like, tie it all in together of what he was saying. We were informed by the witness and the others that shortly after the hearing, so this is referring back to the hearing that he had 13 days previous with Judge O'Malley, who I guess, he's buddies with, right? He's hitting him up. 1:53 p.m. sliding into his inbox, right? Via his personal iCloud account. He knows what's up. He understands the assignment. About getting the affidavit that Chris Albert was seeking a harassment prevention order against him, is my understanding. The proceeding without an insider working in the courthouse, so they're saying there's an insider. This super secretive thing. Meatball Morrissey's ex parte communication, yep. This knowing and willful violation begs the question whether they were equally discoverable responses from the judiciary, and if so, did Morrissey cover them up or delete them? Things always seem to go missing, right? I would love to know. Let's get a tech expert on that, right? Maybe we can call your buddy, the like British dude from Canada to explain how the deleted file isn't actually deleted, and then give his infomercial about how amazing his product is. The other obvious issue raised is whether there are other discoverable communications memorialized and hidden away on his personal devices, and I wouldn't be surprised if there was. Like, between who? Like, who are you talking about? You're so worried about Bill Reed talking to the feds. That's why we know you want his phone records. Don't play. If you wanted to find out whether or not Karen Reed made that call to her father at whatever time it was, 1 a.m., whatever it was, you could see on her phone. You have her phone. You have those extractions. You could see that. Why do you need Janet and her phone records, right? And I think Nathan Reed too, right? All the Reeds. So if you want to find that out, then they have every right to figure out who you've been talking to, right? Who you sneaking off to? Engaged in a scheme to avoid discovery and public record scrutiny of his attempt to influence justices against Mr. Carney, he cannot now be trusted to simply agree and comply with the court's order to provide all such communications when he has already been caught. The defense now calls Meatball Morrissey. I mean, that's where this is going. That's exactly where this is going. And I hope and I pray. I hope and I pray that we see the day that either Tim Bradel or Mark Betterow gets to cross-examine Meatball. How amazing would that be? That'd be like the frickin' Super Bowl. He has displayed a brazen proclivity to skirt public records and discovery rules. As such, he has shed himself of any presumption of compliance with the rules. The appointment of a special master. It sounds so dirty. It really does sound like a dirty innuendo. The special master. To ensure compliance with a strong and broad discovery order and is appropriate in these circumstances. The Lampron case has set the standard for Rule 17 motions, and the hardest obstacle to overcome is the fourth provision, which states that applications must not be a fishing expedition, which is exactly what they like to refer to. Before ordering that a summons issue for such records, a judge hearing in Rule 17A2 motion must evaluate whether the Lampron requirements of relevance, admissibility, necessity, and specificity have been met. Commonwealth versus Dwyer. Specifically, Rule 17A2 requires that the parties moving to subpoena documents to be produced before trial must establish good cause, satisfy showing, 1, that the documents are evidentiary and relevant, 2, that they are not otherwise procurable reasonably in advance of trial by exercise of due diligence, 3, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial, and 4, that the application is made in good faith and is not intended as a general fishing expedition. Commonwealth v. Dwyer. Yeah, exactly. So you can't just say, like, hey, we want your phone, Morrissey, because we want to see, you know, whose pickle you're diddling. we want to know, we want to know who you've been talking to, who you've been colluding with, because you're doing shady stuff. Why are you emailing the same judge who presided over Turtleboy's case 13 days prior and saying, you have to stop this madness. You have to. Unless you were a scared meatball, which you are. Because it's all coming back to you now. In the words of Celine Dion. Here, the statements in discovery sought are potentially exculpatory and reasonably expected to provide evidence shedding light on prosecution bias and improper ex parte communications, prejudicing Mr. Carney to the court. Whereas, I'm adding words, where D.A. Morrissey personally possessed and used witness statements in order for him to personally provide all such undisclosed statements is warranted. Yeah, he was like, I want it and I want it now. In the circumstances, the defense is amply justified in looking for any and all information concerning statements and ex parte communications from the involved parties for cross-examination, all relevant, powerfully exculpatory evidence. The information in the records is not obtainable in any alternative, trustworthy, and admissible manner. That's a polite way of saying we don't trust anyone at this point. So, cough it up. Buckle up, Buttercup. And prior inspection is necessary for a fair trial. The information request is based on the personal knowledge of the undersigned after viewing the aforementioned whistleblower information attached here too. Finally, the records sought are not a general fishing expedition into immaterial areas. See Commonwealth versus Lampron, setting forth requirements for summons for third-party records. Rather, the bias and potential bad faith of investigators and their collusion with witnesses for improper purposes is always relevant and admissible. Exactly. We're talking about witnesses that are also in the Karen Reed case. Chris Albert. Was he talking to Chrissy A? Was he going to D&E Pizza, sneaking off during his lunch break? Having a fireside chit-chat with his favorite pizza boy? Gabe, the Queen of Canton. Queen Poop. I mean, are you not seeing a problem here, buddy boy? I think he's like, I don't know. He's too old to have a midlife crisis, so I just think he's having a crisis. He's just like grasping at anything, at that cup of grab-ass. And he can't seem to get a taste. For the foregoing reasons, the defendant asked the court to authorize the clerk magistrate to issue a Rule 17 subpoena compelling the production of the records as listed above and for entry of a Rule 14 order as requested. Respectfully submitted, Deuces, Aiden Carney, Timothy J. Bradle. Very nice. So this is going to be argued on December 2nd. And if you're in the area, check it out. Like I said, I will link this doc or article in my description box below. But I thought that was pretty big news. Again, not just for Turtleboy, because again, it's like, after all said and done, when Karen Reed gets acquitted, all of this stuff with Turtleboy is going to end. They're just prolonging it as long as the retrial is going to go on, right? As long as that's going to get pushed out. Now, whether or not the civil suit ends up getting dropped or that continues to push through, whatever happens, what if anything, with the Karen retrial, I just don't see them pursuing this any further than that, which is why I feel like they're playing the delay game so much, why they haven't responded to any of this, because I also don't think they know what to do. Like, they're a bunch of chickens running around without their heads on. So, with that being said, if you enjoyed, excuse me, I'm like definitely getting sick. If you enjoyed today's content, make sure you hit that subscribe button. Make sure you hit that like button if you liked it. If you didn't like it and you're hate watching, that's cool too. You could just scroll on by and watch something that makes you feel good. That's fine. You do you, boo boo. Or hit that notification bell, and hit that notification bell so you do not miss the next Karen Reed / Turtleboy update from me. And with that being said, I will see all you beautiful people on Monday. Have a fantabulous weekend.